I am Kelsie Toole. I am your residential sales executive here at Chicago Title. I have been in sales since July of 2014, and I originally started with Chicago Title in July of 2003 as a receptionist. And so I kind of learned my way through this business almost 20 years now. And I appreciate the opportunity to kind of share with you what to look for in a title commitment, why title insurance is important, and how to explain this product to your customers when they give you a hard time about it. And then hopefully convince you to close with Chicago Title. First and foremost, let's see if I can share my screen. And we are recording this for anybody who wasn't able to join. I will be sending out a video on YouTube so that you can hop in and look at it later if necessary. Okay. Da-da-da. Welcome to my screen. Good morning, friends. Thanks for joining us. Almost here. Let me try this share thing again. I appreciate your patience with me, guys. Look, it's me, like 4 times. Hello, hello. I clearly should have gotten some help. Okay. So this is not going to work. Let's try one more thing. I apologize. I appreciate your patience. So I'm just going to share my screen. You're only going to be able to see the PDF, not me. I hope that's okay. Good morning, good morning. That way, hopefully, your husband makes you wear red on Fridays. All right. If you guys could put in the chat that you can see the PDF, I would greatly appreciate the knowledge. And here's my contact information. If you don't know how to get a hold of me, I'm a great resource for you if you have questions about a transaction before it's in process, or if you're not able to reach your closer and need immediate help. I'm always a good resource for you. Thank you, Denise. Okay, so title insurance, we're going to talk about what it is, why it's important, how you order it, the title commitment, and if we have time, we're going to touch base on Chicago Title Now and how you can quickly search properties for free using one of our services. So what is title insurance? When you buy or refinance a home, title insurance confirms that there's no dispute over who has rights to the property. You pay for the title insurance up front to protect yourself from future claims, even though that insurance does insure you in arrears. So the warranty deed is dated, say, March 16th, 2022. It insures you from everything prior to March 16th. In case somebody comes back later and says they were owed money, they had a tax lien on the property, they have the right to the property because they inherited it, all of those good things. A couple more people to hop in here. Good morning, welcome. It gives your buyer and your lender peace of mind that any disputes or restrictions are resolved or known. When you work with Chicago Title, we've been in business for 175 years. You can trust that we will be here to settle any claims that might come up in the future. So that is what title insurance is, and hopefully that'll help you explain it to your clients. Why is it important? Chicago Title will confirm that the deed is drafted correctly, that it's recorded correctly, and that the seller has no prior interest in the property, or that your lien is perfected if you're the lender. Our examiners do verify what liens are on the properties. They search extensively to look for any lien that might be out there. If your property is in bankruptcy, give us a heads up so that we can make sure to check the bankruptcy courts. If you know what county they filed in, that's super helpful. Those are really hard to find. An examiner will not just look for a bankruptcy. We need a heads up on those. But other outstanding liens, so that Chicago Title can pay any outstanding liens at closing and make sure that they are released properly so that your ownership interest or lien is perfected correctly. We also take care of the money, and I think that's very important for your seller to know, and maybe even your borrower on a refinance. Anybody that's paid at closing at Chicago Title, we're ensuring that they are paid and that those funds are good. So you're not just taking some random check from a person like when you're buying a car. You know, we're going to wire those funds into your account, and if it's a lien, we're going to make sure that it's released if it was recorded with the county recorder. So does that make sense? Does anybody have questions about that before we move on to the title commitment? Okay. Ordering title insurance, just shoot us an email, basically. We need, if you're a real estate agent, we want the contract in its entirety if possible. We'll accept whatever you send us happily, but anything that you provide to your broker, we would love to have a copy of. And we need contact information for the parties involved in the transaction. So if your customer is the seller, we need the email address and the phone number for the seller. If it's the buyer, email address and phone number. That way we can take the best care of all your clients. Also, we would really like to have the email address and the phone number for the loan officer. Real estate agents, this is one of the pieces that we rarely get. We just have that little line in the base contract that says, closing with Kelsie Toole's bank. Kelsey's the loan officer, and it doesn't give my phone number or my email address, and you're trusting that my closer knows to Google it and that we Google the right person. So a copy of the pre-approval letter is fabulous because then we even know what type of loan they're getting and we can set up the commitment correctly from the start. When you're ordering a refinance or you're requesting a commitment from us, those requests should include the borrower's name, the address of the property, how you want the lender's name to be listed on the final policy, the proposed insured. What is the loan amount? Please provide a loan number so that we can put that on the closing protection letter. If you need extra items for underwriting, like a closing protection letter, chain of title, whatever else you might need, please include that in your request. And then, of course, contact information for all the parties that are going to be included in this transaction. A couple more people to hop in here. Perfect. Okay, does anybody have questions about how to order title insurance? Great. Good. Feel free to pop those questions in the chat as we go along. And I don't know if you guys noticed that I had included some documents in there for you to view. If you like that kind of thing, we do have that available for you. Okay, so here's our contact information. We have 2 offices that primarily we want you to work with in Kansas, off of K7 and Johnson Drive. I've got Eloise Yonke and Chris Lutman. And then, of course, in Missouri on Tudor Road in Douglas, Lee Summit, I have got Kelly Schutte, formerly known as Kelly Jones, and Julie Brilhart ready and waiting to work with you. All right, now we're going to switch over and we're going to get to the real nuts and bolts of this presentation, which is the commitment and what to look for when you're reviewing it. So appreciate you guys letting me know that you can see this. Give me like some thumbs up. So when you receive a commitment from a title company, the first page should look something like this. And this is going to tell you who is underwriting the transaction. Chicago Title is a direct operation here in the Kansas City Metro. So you will always see our commitments come through from Chicago Title. Other title companies can broker who they're working with. Maybe they're only underwritten by one title company, maybe they have choices. So to pick on Continental Title, you would possibly see a commitment come over from them that had Fidelity National Financial as the underwriter and also had First American as the underwriter. If you're working with the Liens, you might see Westar and or Alliant. I actually have no idea who underwrites for Alliance. I apologize. But if you're concerned about who's holding, who would be responsible for any claims, this is the page that you would go to. And if your customer is savvy enough to be concerned about some such things, you could request that Fidelity National Financial or Chicago Title be listed as the underwriter on your commitment, even if you were closing with another agent in the Kansas City area. We do underwrite for most of the title companies here in the Metro. So that's your first page of your commitment. Questions about that? Thank you, guys. Okay, perfect. The next page, I feel like this is the most important piece for you to look at when you are reviewing a title commitment. This is the most important page for you to look at when you're reviewing a title commitment, the Schedule A. So at the top, typically, this is the 2016 version of the commitment approved by the American Land Title Association is what Chicago Title uses, and most everybody uses the 2016 version. Most lenders require this policy to perfect their lien. Usually in the top right-hand corner, you're going to find the file number. Issuing office and settlement inquiries are going to be listed here. It's blank for the purposes of this fake commitment, but a lot of times you will find contact information for your closer on the Schedule A. The property address will be listed. Please know that title companies do not insure the property address. We insure the legal description. That property address is either coming from your contract or from the assessor's site. And the assessor typically pulls that address from the last recorded deed. They don't verify if it's correct. Those are things that we just kind of work through in a closing situation. Number one is the commitment date. You do want to take a look at that. That is how far back your examiner was able to go, and it is the date of the oldest document. So in this case, March 2nd, 2018, that is how far back the court clerk would have been able to go to verify judgments that were against the property. Lenders typically do not want the commitment date to be older than 45 days. At closing, Chicago Title does do a run to date. It's our procedure to run the file to date 48 hours prior to closing. And make sure that nothing has recorded in the meantime, either with the court or with the recorder of deeds, that would affect the lien possession of your client. That is why we ask for 48 hours. Well, it's one of the many reasons why we ask for 48 hours notice for closings, so that we can make sure to be able to run that file to date. Number two, the policy to be issued. An owner's policy and a loan policy is being issued on this transaction. We do split transactions in the Kansas City market, so sometimes you might just see a loan policy if we're only closing the buyer, or you would only see the owner's policy if we're closing the seller. What you as a customer want to look for here is that the names are spelled correctly of your buyer. Does it match the contract? When you write a contract, we do pay attention, and if you put Betty B. Buyer, that's what's going to go on the deed. If they want to go into title as Betty Boob Buyer, then the contract needs to state that. The loan policy, this information is going to come from our request for title from the lender, how we show the lender proposed insured. In Kansas and Missouri, number 3 always says fee simple. That's just how we do it. Not as important to worry about. And then number 4, you always want to pay attention to. Number 4 needs to match the seller on your contract. So in this case, Samuel S. Seller and his heirs or devices of Sally S. Seller deceased is who's entitled. So if your contract says John Smith, then you have a problem. It probably in this case says whoever, hopefully it says Samuel Seller, the heir of Sally. But if it says like Mike or Pat or one of his brothers or sisters, then you'll need an amendment to correct. You'll need to call your closer and have a discussion with them about how to move forward. But that's one of the things we want you to look for. And then we also want you to look on number 5 that the legal description matches. I urge you to never write a contract that says the legal description will be determined by title. Please do not do that. What if there's more than one lot? What if 1234 Made Up Street is the mailing address for 6 different properties in Jackson County, Missouri? So, you know, at least lot 1 and the subdivision name at a bare minimum should be included in your contract so that you can ensure that we're deeding the correct property. My Aunt Dieta recently sold her house in Arkansas, and she called me and she was like, hey, they sold the neighboring lot and my exclusive right to sell only says lot 6, and they deeded lot 6 and 7. And the exclusive right to sell had the legal description on it, but the contract only had legal description per title. That's what the buyer's agent wrote in. And best I can tell, the listing agent never corrected it. I'm not sure what they're doing there, but it's a hot mess in Arkansas with them figuring that out. So please have at least a shortened version of your legal description in the contract. Okay, that was a lot. Questions about the Schedule A? Hi, Keith. You made it. Sorry I made you wait so long. Okay, great. So yeah, Schedule A, that's what you're looking for. Is your buyer's name spelled correctly? Is your lender listed correctly? Does the seller match the contract? And number 4, and is the legal description what you're purchasing or what your client intended to sell? Awesome. Okay, now we get to the fun stuff. The next part is the Schedule B. Schedule B is going to show things that have to be resolved in order to, Schedule B Part 1 specifically, is going to show things that have to be resolved in order to close. So you got to pay us. And a proposed insured needs to, number 1, a proposed insured needs to be provided to us. You have to provide the funds that you agree to contractually, and you have to pay us for our services. And then we need to execute those documents. So, you know, that's standard verbiage on all the contracts. Most people don't pay much attention to 1 through 4. Number 5 is any mortgages that are recorded against the property. So you've got your first mortgages, you've got home equity loans. If there was an old mortgage that had supposedly been paid off and never been released, you might see it here. So you want to pay attention to amounts, dates. The trustor is the person that is responsible to pay back the loan. The beneficiary is the person who benefits from the payment of the loan, what day it was recorded versus what day it was signed, and the document number with the county. Missouri is a trustees state, so you would see who was listed as the trustee. The trustee, it was explained to me by Kelly Dunn-Walters that he's like, if you go to court, if you went to court, the king would sit at court and solve problems for people. And both sides would come, present their case, and the king would decide what was the best thing to do. The trustee is like the king. So both sides come to him. He or she is supposed to act as an unaffiliated third party in a foreclosure situation or whatever might come up in regards to the lien. Typically, the lender determines who the trustee is. So yeah, mortgages need to be paid off. As a part of closing the transaction, we greatly appreciate the seller providing us with the loan number for any mortgages that need to be paid, the last 4 digits of their social security number, and we will have them sign an authorization to receive payoff information. That's sent to them securely through Start in here, and we can talk about that more at another time. Number 6, we require marital status of all parties involved in the transaction. If there is a spouse, we want them to sign away their interest. So we will ask, is Samuel married? Even though he inherited this property from Sally and his wife has no interest in it, in his opinion, we would still require his wife to come in and close if he had remarried. Number 7, this property apparently has been condemned, and the city of Blue Springs came in and filed a dangerous lien in it. So they went and they boarded up the property, or they had to do some sort of maintenance to it. And so any funds that they've spent on maintaining that home is attached to this lien. And we would reach out to the city of Blue Springs to get an invoice for payment and then work with them after closing to get a release. So that's what a dangerous building looks like. I hope I already said that we used to call this the train wreck commitment. These are all the bad things that you could possibly see happen on a commitment, or at least that we could think of. Number 8, Homes Association dues. It's not always, this is what a lien would look like. We always check at closing if Homes Association dues are due. And we greatly appreciate when you put that contact information and the seller's disclosure, or at least advise your customer that we are going to want contact information for the treasurer, phone number and or email address. How much do they pay? Are there any initiation fees for the new owner? We need that information in order to secure clear title. If they don't get that information, you end up with a lien on your title work. It looks like this. This $897 amount is what was due on September 1st of 2010. It's not necessarily what's due now, 12 years later, right? And yes, this lien could have been out here just waiting for them to have some sort of financial transaction on the property to confirm that they would get paid. So that's the first page of the Schedule B. If you notice on the bottom here, there's all this fun little information. Title, a lot of times you'll find file numbers down here. You'll find what time the commitment was printed, so you know when it was last updated. You might find the name of the examiner, fun little fact, and then of course what policy they're writing it for. Questions? Am I going too fast? All right, cool. Other fun things that you might see or that you didn't know could attach to title work. A judgment. So let's say your customer went out and bought a Ford truck and then decided they weren't going to pay it back. And Ford not only repossessed the vehicle, but they also went through the trouble of going to court and suing your client. And your client didn't do anything about it, so a judgment was reported with the courts. That attaches to any real property that is owned by your client, including this home. So if they own more than one home, it would attach to that as well. If they have any asset, judgments attached to those. So we would require that this be paid off or a release provided in order to close. Again, anytime you have liens on your commitment that you did not expect and you want to know how to best resolve, you want to reach out to your favorite closer at Chicago Title to work out a plan to get that taken care of. And it's our habit that within 48 hours of the commitment being sent, that somebody reaches out to you to let you know we've had a chance to review the title commitment and it looks great, and or we need to be concerned about these issues. Give us a call to discuss. Number 10, a judgment for installments of spousal and or child support. So both alimony and child support liens do attach to any real property owned. It doesn't mean that it has to be paid off in full. It just means that we need proof that it's paid up to date. We can get this by confirmation from the state or the spouse, or if it's an adult child, could sign a release to close out that obligation. Number 11, a federal tax lien for the amount shown with the United States of America. This is what an IRS tax lien looks like. It even has a recording date. So if your client said, that's not me, we can provide them with an actual copy of the document that shows this. Typically, my experience that when you get to this point of having a federal tax lien, that your client has had somebody shown up on their door, a tax collector, and provided them with a card on how to contact them so that they can resolve this. There's always somebody that has done this, I promise. Sometimes it takes 3 or 4 weeks to get to that point, but then they're like, well, yeah, I have this number for so-and-so. The sooner we get that, the sooner we can clear this lien. Yes, you can do partial releases for IRS tax liens. Yes, you can. It's like negotiating a short sale. So don't think that you can't close just because you got an IRS tax lien. Call your favorite closer at Chicago Title. We'll work it out. Try to get to a place. As long as your customer works with us and we have good communication, we should be able to resolve it. And they realize they have to pay it. So number 12 is a bankruptcy. This is what a Chapter 7 bankruptcy would look like on a title commitment. If your client has declared bankruptcy, the questions that we typically ask are, is it Chapter 7 or Chapter 13? And did you reaffirm on the house? So if they filed Chapter 7, but they said that they were going to continue to, they wanted to keep their home and continue to pay the mortgage that's on it, then we should be able to close without any issues on a Chapter 7 if the house is listed on the Schedule C and it's discharged. If it is not, or it's a Chapter 13, then it's very possible that we need permission from the court to sell. So that's usually my first question when somebody asks me, hey, my client's in bankruptcy. Is that going to affect their ability to sell this home? You need to say to your client, call your attorney and ask them if you need permission from the court to sell. Call your attorney and ask them if you need permission from the court to sell. That's the best thing that they can do, because if they do, a motion can take 30 to 45 days, and you don't want to find out about that after you're under contract. When you have sad people, they're deceased, they're in bankruptcy, or they're divorced, I strongly urge you to get a preliminary commitment. Please email over a copy of your listing agreement to your favorite closer at Chicago Title. We'll go ahead and have the examiner search it. Let us know why they're sad so that we can look into that specific case, and then we'll let you know what issues we come up with. If it's a regular resale transaction, we don't really necessarily require a preliminary commitment. Things turn so quickly. We're getting title commitments out in 3 to 5 days, even throughout COVID and all of the messiness that we had there. But if there's stuff to fix, you want to get that early so that you have time to resolve those issues. Does that make sense? Okay, perfect. This is still the Schedule B, Part 1. These are items that would need to be cleared up in order for you to close. Number 13 is a mobile home. I got to be honest with you, I'm not very familiar with how to resolve this issue. I know that Kelly Schutte has done a bunch of them, and Eloise Yonke is very familiar. But my understanding is that basically if a trailer is on a property, it may still be considered a vehicle and have a title with the Department of Motor Vehicles. And if you want to affix it to the property, you have to go through some steps. But occasionally there is a modular home that's considered a motor vehicle until, while it's traveling to the land. And then once it's affixed, something has to be done to affix it to the property. It's not my arena. We do have experts here to fix it. It does take time. It takes cooperation from your client. They have to be willing to do the work to get it attached to the property if whoever they bought it from didn't. So that's fund number 13. I used to just always refer them to Ray County Land Title, but it doesn't always work. Number 14, unless the company has furnished evidence that a trailer or mobile home is taxable solely as real estate, our policy will be issued with the following exception. So if they don't want to affix the property, then we state in the final policy that it would be taxed as personal property, not as real estate. And then when you record a deed of trust, like if you're getting a mortgage on the property, then we record. The deed of trust would need to state that they're aware it's a mobile home. Can I repeat what SAD stood for? Yes, I can. SAD people, it's not really an acronym. SAD people are people that are divorced, bankrupt, or have deceased individuals involved with the property. So dead people, broke people, divorced people. They have situations and they need our help as real estate professionals. They have very complex situations. So when you have divorced, bankrupt, or deceased individuals, please send over a copy of the listing agreement to your favorite closer at Chicago Title, and we'll get a preliminary report started. And we ask for the listing agreement because we want to know that it's listed with Chicago Title and we're not doing this work for somebody else. Make sense? So, and they would still not pay for it until they close. Okay. Mobile homes. Number 16. Specifically, we're going to talk about some deceased individuals here. So in Missouri, so we have 3 different types of dead people. Please excuse my bluntness. You have people that planned for their death. They prepared a beneficiary deed. They recorded it with the county because it's not any good if they didn't record it. And that property just deeds over to whoever's on the beneficiary deed nice and neatly. And that's assuming that the beneficiary deed had a correct legal description. And then you have people that died and they did a will. You have a year in Missouri to probate a will. I have to refer to Eloise's expertise when it comes to Kansas properties because I was only a closer in Missouri. But you only have a year to probate. So you would open up probate. The court would order that the property be sold and/or a personal representative is assigned on the property. And then you can sell. So a motion to sell is filed and approved, or a personal representative is given power to take care of the estate and then they could sell. If it's been over a year, then an affidavit of heirship can be done. And basically what we want is a friend of the family, somebody who is familiar with all of the facts, but not actually related to anybody that would own the property. They would sit down and sign an affidavit that states who the heirs are of the deceased. Do they have surviving parents, spouses, children, and who are those people married to? And then everybody that's listed on that affidavit is now in title. It gets recorded with the county. Those people are in title, and then you do deeds to deed them out. We prefer that you go through an attorney to prepare affidavits of heirship because it gets very interesting when you're dealing with that many people, and Chicago Title would like to remain an unaffiliated third party to the transaction and just make sure that instructions are followed, not negotiate sale. That makes sense? So another reason why when you have a deceased individual, go ahead, send over the listing agreement for you who you think owns it so we can take a look at it. And go from there, and we can help you throughout the way. It does really help an attorney to have a title commitment to present as part of their motion to sell. That way they know if there's any liens on a property. When you have deceased people, let's say that Samuel Seller, he inherited this property from Sally, but he has a federal tax lien, right? That attached to the property, and you don't know that until you start running Sam's name. All kinds of fun stuff happens with dead people. I bet you guys. All right, questions about that? Okay. That is the end of Schedule B. Oh, no, I'm sorry. Oh, yes. Powers of Attorney, number 17. So, yes, Chicago Title will accept a power of attorney. As your residential sales executive here at Chicago Title, I would just like to say that we don't like them. It's not to be used for convenience. When you sell a home, it's not supposed to be convenient. You know, we're not going down to the grocery store and picking up a gallon of milk. It's a house. It's an asset. It takes a minute. That being said, there are legitimate reasons why people need powers of attorney. They're in the military. They're disabled. They legitimately do not have the ability to sign their name or know what day it is. You know, somebody's taking care of them. They're in jail. Things like that. We would like you to send over the power of attorney for us to review prior to closing so that we can confirm that we have the ability to use it. And we need the original for recording purposes. If it hasn't already been recorded with the county, it does need to be a durable power of attorney. You cannot use a medical power of attorney to sell a house. It needs to be specific to the property. Anytime you have questions about powers, please let your customers know. They come in and they have some idea of what they're doing when they're signing power of attorney, but they don't really know when they're buying a house how much they actually have to sign. So it would say, you know, Michael Toole by Kelsie Toole, his attorney in fact, on every single document and the date. You can't abbreviate it. You got to write the whole thing out. So you got 150 pages to sign. It's a commitment. It's going to take a while to sign. It's not supposed to. So that's that. Number 18, sometimes there's judgments on a property, like there's a class action lawsuit that has affected this house that you're selling. So in Sugar Creek, once upon a time, they sued Amico and won, and we aren't clearing, you know, that's an agreement. We let your client know that there's already been a lawsuit in this case about hazardous materials in the area that might affect groundwater. You know, they have knowledge of it. Chicago Title's not protecting them in this case. They want to buy the house, they want to buy the house. That would be one of those things that they're reviewing in the title commitment as part of the inspection process and could cancel because of, right? Hopefully you would know before the title commitment came out that Sugar Creek had a cancer cell, but if you don't, now you do. I know that there's another one in Kansas. I'm just not as familiar as I am with Missouri. 19. Lenders love and adore that we put the 24-month chain of title in the body of our commitment. So the last warranty deed that was executed was Joe Babb's Building Company to Samuel and Sally, husband and wife. It was recorded on January 1st, and this is the document number. So lenders want to know if the property has been flipped in the past 24 months. Is there some reason why they would need to over-question the value of the property? Plus, as an examiner, we want to look at that deed and make sure that it was notarized correctly, it was executed by the right person, the vesting was right. You know, was it an insured deed? Was it insured by another title company? Or did they just randomly whip it up themselves and try to take title to this property in error? There are 21 reasons why that might happen. And I've included that as one of your attachments, things that we look for in deeds that cause them to be erroneous. That is the purpose of the 24-month chain of title. Oops. Number 20, the company requires full payment of premiums for the insurance policy. Number 21, in Jackson County, Missouri, a certificate of value, and in Johnson County, Kansas, a survey validation questionnaire is required to be filled out and recorded with the deed. The attachments, Suzanne, were supposed to be in the chat. So if you go all the way to the top of your chat, like click on your chat button and then scroll to the very top. Yesterday at 8 o'clock, I shared 7 attachments and you can download them from your computer. I can email them to you guys if you want me to, but sometimes large emails don't go through. So I figured I'd just attach them to the chat. Hopefully that answers your question. The certificate of value and survey of validation questionnaire, or whatever it is, basically we're letting the county know what the property sold for. Missouri and Kansas are non-disclosure states, so they can't make that information of public record, but I'm pretty sure that the assessor does pay attention when they're figuring the value to assess the property on. I guess it's all counties in Kansas, not just Johnson County, Kansas. All counties in Kansas require an SPQ to be recorded with the deed in order to, yeah. Closing protection coverage. Most lenders require a closing protection letter to insure against acts of fraud and theft. In Missouri, we are required to issue a closing protection letter for buyers, sellers, and then when the lender requests. That law went through after the recession when a lot of agents, just something happened and the monies were stolen. So that it ensures more of an escrow piece. And then electronic, we do record documents electronically and there's a fee for that. So we disclose that as one, we require that fee to be paid in order to close an insure. So that's the Schedule B Part 1. Schedule B Part 2. These are standard items that are going to be listed in the final policy. So we do not insure against liens that we, if they knew that so-and-so had come and painted the house and did not inform us that the home was being painted and that that work had been done in the last year and was not paid for, and we weren't advised of it, we're not insuring for that. That's on the seller. We would go back to them. If it's not a public record, then we don't have the ability to search for it and make sure that it's taken care of. So that's basically 1 and 2 and 3 on your final policy. Number 4, we have the seller sign an affidavit at closing confirming that there hasn't been a change to the survey, that they haven't done anything to change the property line, like put sprinklers in that would negatively impact their neighbor's yard, right? So if you want survey coverage and you want number 4 to be removed from the final policy, then you do have to order a stake survey and provide it to your closer to be recorded with the deed. And then you can get number 4 removed. It is not common in the Kansas City market for this to be done, not even on new construction. When I started in this business in 2003, we would get a sketch of new construction lots to confirm, was the driveway on the property? And we just have that much trust in the plat that's recorded with the county these days, that survey coverage just happens. So number 5, again, this is for work that was done to the property. If it's not a public record, if they have not recorded a lien, then we can't ensure that it was paid. Taxes and special assessments that are not public liens, we can't ensure they're paid. And then we start giving you kind of, for your information, this is the parcel ID number. This is what we're showing the county has the property assessed at, appraised for. What we show last year's mill levy was, so you can calculate future taxes. Are there sewer assessments? Are there any special bills? You've got like those little lake properties that have special issues that they assess for on an annual basis. Did the city go by? This is a special tax bill for $456 because they mowed the yard. And they have agreed to let you pay it in installments, but this guy, hasn't lived there. They're deceased, right? So we would want it paid at closing in full. We can pay the Jackson County collector, but that confirms how it has to be paid. They have easements, right? They have easements so that you can run the cable line and the electric wire and the sewer so that you can have plumbing and lights and Netflix. So those are standard against the property. If you have a client that is concerned about them, we can pull them and they can read them, but it will be included in the final policy. It will not be removed. Covenants and restrictions for homes association declarations, those are included in the final policy. If it goes with the property, it's part of the plat. If they want to review those, you can request a copy from your closer. Please send an email. If the lender wants to look at them, please send an email for what you want, and we can send that over to you for you to review. These are very handy when you have a condo. Terms and provisions of the final order, that's what it looks like because of that Amico settlement. This is not common. Number 10 and 11, very common. And then, of course, any state court judgments or tax liens that have not been recorded, that are not a public record, we can't insure against those. The buyer's name to confirm if they have federal tax liens or state tax liens prior to closing. We do that as part of the commitment process so that we can ensure a lender's lien position, because that would take precedence over your mortgage if they have a federal tax lien, correct? So we do that. Page 11, in Missouri, the state of Missouri Department of Insurance requires that we disclose the split between the title insurance premium that is paid to the underwriter and the portion of the owner's policy amount that is paid for exam, for whatever reason. So you'll find fees for your title insurance towards the back of your commitment in Missouri. In Kansas, it's on the Schedule A because we can record the whole amount. So the policy is $531 for this sales price in both Missouri and Kansas. But the Department of Insurance requires that I disclose this split for you in Missouri. So I can't just put $531 on the Schedule A next to owner's policy. Super fun. In Missouri, they also they allow us to charge up to $25 for a closing protection letter. The standard fee, all title companies charge it. It's $25. In Kansas, you still get a closing protection letter. There's no fee. I hear rumors sometimes that they're going to change that. Don't know if it ever is going to happen. So. Oh, Suzanne, you're not saying in it? Yes, I will. I'll email them to you. Anybody who would like the attachments, maybe they're not in your chat because you hadn't joined yet. Yeah, I'll figure that out later. But if you want to put in the chat, that you're interested in the attachments, then I can email them to you. The last part of the commitment is the commitment conditions. It defines all the terms in the commitment, our right to amend the commitment as things change and we run the file to date, our limitations of liability. Basically it's the legal jargon, and I apologize. I am a sales executive. So I am pretty relaxed when it comes to this kind of stuff. Thank you, Sherry. I'll get that to you. I don't speak commercial well or at all. And number 8 talks about pro formas. I know that in commercial, the commitment can be mocked up to look more like the final policy. And I apologize, I just used the word mock-up. We get instructions. They're constantly working on amending a policy in commercial as you work through the file. It's a different beast. If you guys are interested in a Title 101 class, a Title 102 class that's more geared toward the complexities of commercial, I can chat with Scott Hanford or Brad, our attorney, and see if they can host that. Things to look for in the future. But basically, for your standard everyday real estate agent and loan processor on a residential deal, page 12 and 13 will never concern you. Some of the things that I'm going to send you are commitments and judgments that affect title. It's a fun little piece to have in your real estate pocket. When people ask about title insurance, these are things that can come up. When you've owned a property for 5, 10, 20, 30 years, there's all kinds of things that have happened with your finances in that time that affect your property. Again, title insurance is in arrears. It is important that they get it. They were only protected prior to the date of their deed, not after. And then things that we look for, 21 reasons why you need title insurance. I don't know if you guys have been following me on Instagram. I've got a fun little WTF weird title fact that comes up that we're going through these 21 reasons for. When you send over an order, I do have these fun pamphlets. You know, this is the information that we're looking for. You know, who's your seller? Are they married? What's their address, phone number? Who's their current lender? Who's their homes association? Buyers, same kind of information. Who's their loan officer? Do they do earnest money deposit? That kind of thing. You guys have transaction worksheets. If you don't have a transaction worksheet, then you can use these. Questions? I will get those to you, Keith. Absolutely. Yes. Tina will take care of that. And Jennifer. Okay. Last but not least, Chicago Title offers a service. It's called Premier Services. You can go to chicagotitle.com and register for this product. Basically, it will allow you to search anything of public record about the property. You can search by name, address, or you can take a picture of the property and find out everything of public record. It is a great start for a listing. If you are a loan officer or a loan processor and you are regularly doing refinance transactions, it is a good supplement to the credit report to see if the match up mortgages. Maybe they have more than one house and you're trying to find taxes and insurance on those. It is a nationwide product, so hopefully you may be able to find it. It is limited to what is a public record. So there's a great amount of information in Jackson County, Missouri. Just, all kinds of good stuff. But if you go to Johnson County, Missouri, you're not going to find anything. Like, you got to go down and talk to Todd at the courthouse to find out what the taxes are and what the mortgages are. Truman Title's making a buttload because they're not a public record out that way. So, however, if it is a public record in Florida, California, Missouri, you have access to it through chicagotitle.com. We give our clients 100 free searches per month. If you need more than 100, I won't have that problem. Please bring it to me. Let's figure it out. And please close with Chicago Title. I hope that this has been valuable to you, that it helps you in the future when you're doing real estate. And yeah, that's all I got, guys. That's it. That's all. How'd I do? Did I do okay? Yay, thank you. I appreciate you guys coming. I'm really excited that how many people were interested in Title 101. Hopefully I didn't talk too fast. Again, I am recording it, so I will send you the YouTube link. If you know anybody else that would be interested in this, I do plan on doing my next class in May, and I'm going to do an Escrow 101 class the third Wednesday in April and review the closing disclosure and the settlement statement that we use here. Thank you, Austin. Thank you, Dina. I will absolutely do it. Oh, thank you, Julie. That's very nice. I'm glad it wasn't too fast. All right, guys, join me on Tuesday's title tip. Thanks.